notice you're not waiting outside the classroom, no inside. Okay, questions? Where started? No? All right. This one's going to be tough. This is poll question. Please take a look. I'm not going to say anything. That's your question. What? Yeah, that's your question. All right. Go. So, I don't know how this one's going to turn out. All right. So this is a quote from the majority opinion of Bergefell. And I was reading it for class today and it just struck out. The court certainly said this. They actually mean it. Who is the unfortunate person who's next? All right, Shiv and my friend. What? I don't go. I don't know what my question is, but go.
I put true.
Okay,
and
good.
Here's the reason.
Okay, good.
I don't necessarily agree that marriage is just between a man and a woman. However, the quote says, "The view has been held and continues to be held in good faith by reasonable and sincere people here and throughout the world." So I think that people who hold this view, this is why I put true, because people who hold this view, that doesn't mean that they're unreasonable or unsincere. That's just their opinion. They're about their opinion. So that's why I put true.
Brittany, what do you think here?
I said false because I'm pretty sure that's they were quoting what the defendants were making as their hold, right, or their claim. So I'm saying that obviously it. Okay, I'm going to try to explain what my point is. Yes, in their view that is, and it is in good faith. But based on the holding of this, it's no longer just gender differentiated. So I don't know if I'm stretching it there. Maybe that's just where I wanted to answer, but that's why I wrote false. I put false as well. Similar to the court was saying that it's not gender differentiated.
But are the people who continue to hold to that reasonable and sincere?
Yeah.
In other words, well, if the court's announcing that there's a fundamental truth that denying gay and lesbian to the institution of marriage is denying this fundamental right, how can these people be sincerely holding beliefs if the court says otherwise?
I'm sorry, I don't understand the question.
If the court spends all these pages you have to read by saying why this right to marriage is so fundamental and significant and foundational to dignity, how can a person hold the opposite view and still be a sincere and reasonable person?
It kind of goes back to the whole idea of like it places him as a bigot otherwise, like we talked about the other day.
So that's why my question here is true or false. Can a person disagree with the outcome in a Bergefell and still be reasonable? Oh,
I
nice.
changed my answer now, it's true. Because I don't think they're bad. I also think that's not hate.
China, you're next.
That's a good question.
Yeah, I told you that was a really bad one.
We're having a good time.
3%.
I think that people can hold whatever opinions they choose, and So long as they're not hurting another person. I'm fine.
Oh, but does holding this view hurt someone else?
Potentially, yes.
Oh, so China puts a wrinkle on it, right? So, I don't mean to pick on this front row, it just happened to be those are the four who happen to be up next. But I don't know, I was reading the case today, and this quote just jumped out at me. Because it seems that the court's saying, it's like, listen, we recognize what we're doing here is a little bit new, and a little bit novel, and we're recognizing this right, which no one argued existed before 2000, 2003, whatever. So if you still hold this view, you are reasonable. It's sincere, right? But the rest of the opinion seems to suggest that holding this view results in, I think China said, hurting people and inflicting wounds, dignitary wounds, on gay and lesbian couples who can't get married in these various states. All right? So I want to jump back to another case. Remember Loving versus Virginia, interracial marriage case? Do you remember how the majority described the Virginia law, which excluded interracial couples from marriage? Remember like what theme they used to describe it? Just broadly speaking. How did they describe the Virginians in that case?
So they said that marriage was a fundamental right.
Good. You know what I'm thinking of?
Bigot?
Yeah, a little bit more specific. Anyone not remember the word I'm looking for? Anyone? White supremacists. Remember? They said that those who hold this ban on interracial marriage are basically white supremacy. Right? That's the verbatim quote from the Loving decision. So here it's a little bit of a different story though, right? The court's not saying that people who adhere to the traditional form of marriage are bigots and homophobes, whatever their synonym you want to use. They're saying they hold these beliefs in good faith and they're reasonable. So then that raises the question, right? If this is an issue that's open to debate and reasonable people can hold different views, why is the outcome in this case so easy for the majority? I mean, I think you're next. In other words, if this is not like, look, they're going out of the way. They could have said, look, if you oppose gay marriage, you're like the white supremacists in 1960 Virginia, right? You're no different than them. They didn't say that, right? They did not say that. They said, look, we're sincerely held beliefs, reasonable, you know. They're putting this language out there. But if it's the case that you can have these sincerely held beliefs, then is this case as easy as a Loving type decision? Is it like, you know, is it that straightforward?
It's not. Right after the quote is stated in the case by
Good.
him, he says that the case does not end there. That had they intended to demean their reality of marriage, it would have been like Loving, and obviously Loving. But they didn't mean to demean them. They wanted to show them that it's not a matter of classification through sex, but that they hold the same views of the importance of marriage and the value of marriage, and sex should not, or gender should not be what determines whether they agree with the marriage or not. Unlike another word, race did determine how they felt when marriage was married.
So is the difference, let me come back to the Ami, is the difference then that in Loving there was an intent to demean and here there was not an intent to demean? Is that what you're getting at?
Here, those that, in Loving there was an intent to demean the people who were in disagreement with the interracial marriage.
Okay.
Here, Kennedy's approach was more of, hey, we understand how you value marriage. Those same-sex couples also value marriage in the same way. Marriage should not be a gender issue. It should not be looked at with the strict scrutiny of a classification of gender, but rather of a fundamental right.
So what Kenny's saying is your sincerely held beliefs are wrong. Your sincerely held beliefs.
Not in its totality.
No, I'm talking about marriage, right? This is what we're talking about. So you sincerely have beliefs in gender differentiated union being opposite sex, right?
That aspect of marriage he disagrees with, but it doesn't end there anymore.
But no, but just stay here for a minute. But he's telling people you hold this belief, but you're wrong. Pretty much, yeah. Yeah. So the effect of this is saying, and so just to the credit of the court, saying, look, we're not calling you all bigots, right? I think Windsor actually did. If you actually read the Windsor opinion, it comes close to saying that. But at least here, they say, we're not calling all of you bigots. We're just saying you're wrong. And that you don't appreciate or recognize the impact of separating marriage in the fashion which you did. Right? So the sorts of laws that have been in the books for thousands of years, even before there were laws, you didn't appreciate what we appreciate. Right? There are certain truths that in a time that you believe that, we are in a different times and different truths today. And, one second, Aaron. And because we see things that perhaps you didn't, then they proceed to the actual decision. Aaron.
So given that it has been a view that's long been held, what do you think, what would you say is the reason that it's suddenly changed? Public opinion that dictates that?
Oh, sure. Yeah, I mean, I don't want to minimize the public opinion change. I showed you that table in class yesterday. The idea of a gay marriage didn't exist anywhere in the world before the year 2000. I think the Netherlands was the first place on earth to have it. And in 2003, the Massachusetts Supreme Judicial Court recognized the right in its own constitution. So we're talking, what, 14, 15 years ago, not very long ago. And in record time, the support for it rocketed up. Right, it's astounding. I mean, in all of your lifetimes, the support for it just zoomed up. So, why? People think there's probably not a very good reason to exclude gays and lesbians from marriage. But my point is, because on this, Ayani read the next sentence, but this point right here in the very beginning of the opinion, where they're saying, your belief is still sincere and reasonable, right? We're not going to call you out as being a bigot. But the disconnect, at least in my mind, is that throughout the rest of the opinion, they say that denying these people marriage is denying their dignity and their humanity. Right? So how can you hold a reasonable belief, to use China's words, as harming someone else? Right? How can you hold a belief that's sincere and reasonable if the effect of it is basically deny a person their fundamental rights? Right? How is that any different than saying a man who's black and a woman who's white can't get married? Right? You're denying them some intrinsic aspect of their humanity that they are. So there's a tension in the majority's opinion, and I think Kennedy went out of his way to try to assuage people that, don't worry, we're changing this, but don't worry, you can keep believing what you're believing. But the effect of his decision is to say, look, if you think that traditional marriage should be maintained and we shouldn't have gay marriage, you're going against fundamental rights, and Justice Kennedy told me so. Erica.
And I think too that one of the biggest frustrations throughout the dissent was kind of mirrored toward this quote, that if good faith, reasonable, sincere people can hold a different view than this, then it should have been left up to the democratic process.
Yeah, that's my next point. Yeah, I was going to get there in a minute. Right. So this is one of the points raised in Assembly, which I'll go to now because Eric was jumping the gun a bit. If indeed there's a difference of opinion, generally you say the democratic process resolves it unless what? When does that not kick in?
Unless it's specifically targeting people's rights.
So then
or
we
taking
go
away a liberty.
right. So then let's go back to footnote 4, our favorite footnote, right? Caroline Products. Generally, the courts will defer to the democratic process, except in a few different circumstances. And as the courts develop this case law, if a fundamental right is at issue, you apply what's basically strict scrutiny. Kennedy never used the word strict scrutiny. That appears nowhere in his decision as like scrutiny. So then we get to the question of how do we frame the right at issue? Now, there are lots of decisions where the courts talk about marriage as a fundamental right. There are lots of them. Go all the way back to Marbury, Nebraska, and elsewhere. But of course, the disconnect is when they were talking about marriage, they were, right, obviously talking about man and woman, right? No one doubts that. Kenny doesn't deny that. So then, John, how do we get from these old decisions going back 100 years saying that marriage is a fundamental right when they were talking about opposite sex, how does Kennedy get that to talking about marriage as a right for same-sex couples?
It basically generalizes to same-sex couples as well by looking at giving a list, but he refers to autonomy of two individuals as having the ability to decide to get married, irrelevant of whether it's same or opposite sex. There are three other principles as well. My notes are a bit everywhere.
All right. So let me go. So Rachel, I think you're next, right?
Yeah. I think he bridges that disconnect through liberty, the word liberty.
Okay, good. Tell me more.
Okay. So I think he takes advantage of the fact that the framers kind of left the word liberty open. It's like an abstract word in the 14th. That I don't know, how I viewed it is Kennedy thought that liberty changes like with the generations to
Good.
come.
Yeah, that's
Or
exactly right.
The intelligence or reasonableness of generations.
Right, so that's exactly correct. So the court says, here's a quote from the opinion, when new insight reveals discord between the Constitution's central protections and a received legal stricture, a claim to liberty must be addressed. Jessica, I'll read it for you again. When new insight reveals discord between the Constitution's central protections and a received legal stricture, a claim to liberty must be addressed. What's going on there? What's he talking about? So let me ask you, Jessica, just a follow-up. In some of the cases we've done so far, Meyer v. Nebraska, Pierce, Griswold, Rowe, even Lawrence. Cut out Lawrence for a second. We'll just do the other ones. So Meyer, Pierce, Loving, Rowe. Does the court simply say that liberty means everything it means today? Have you ever seen a sentence like this in an opinion? We've been here 3 months. Have you ever seen something like this in an opinion? What do judges usually try to do when they're talking about a liberty interest that's not written down anywhere? What do they usually look to? Exactly right. History, right? So we have a case like Meyer v. Nebraska, right? That was the case with the teaching of German. You have Pierce v. Society of Sisters, which was about the private schools, the Catholic schools, right? And in all those cases, they list all these various rights which they deem fundamental. And the reason why they're deemed fundamental is that they're deeply held and they're rooted in history and text, like they've been around forever. The right of a man and woman to have sex and have children and get married existed before the United States long existed. Even in a case like Griswold, they describe marriage with its privacy rights, something that's very deeply rooted, that people have this privacy in their bedroom going back for a millennia. And even in Roe, there was all discussion of quickening, saying, look, see, we're not doing anything new. There was very rarely ever any restrictions on abortion before the viability line, right? You see in all these old substantive due process cases, the judges bending over backwards, maybe even making stuff up, but bending over backwards to try to fit the history. Here, Kennedy's saying, when new insight reveals discord through the Constitution's central protections and received legal strictures, the claim to liberty must be addressed. So he's saying we don't have to worry about history. Now, you have seen a sentence like this, similar, saying that, well, history doesn't help us, we're going to just ignore it. You know what case I'm thinking of? Good review. This is history doesn't really help us, so we're gonna just go on our own and use modern stuff. There's one other case I can think of. Anyone know the answer? Case?
Isn't it Lawrence?
Not, Lawrence, yes, but I'm thinking a little bit of an older case. You're right about Lawrence. Say it. The court says history is not helpful, so we're going to use modern stuff. Yeah, think about it for a minute. I'm not going to give it to you. Wait. You're going to know this.
Is it the Truman one, or like the president?
Not Youngstown, no. Eric?
Was it Lochner?
No, not Lochner. Lochner said this is a deeply rooted right about economic freedom and contracts. Hunter?
Brown.
Got it. Bingo. Bingo. Why is it brown? Which part of brown? Lucky guess. There's a footnote in brown. I'll give you a hint. A footnote in brown that Andre stumbles at the right answer, but he's right. What did the court say in Brown about the history of the 14th Amendment? What did they say? What did the history of the 14th Amendment say about segregated schools? Anyone?
Oh, that, was that when they were saying that white children had normally been schooled within the home and black children didn't normally go to school at all?
No. Were there segregated schools at the time of the framing of the 14th Amendment?
Yeah.
There were. And what did the court say about that? Shrug emoticon, right? They said the history is not helpful to us, we're going to ignore it. And we'll decide this based on social science. Remember that footnote? They said, look, we've looked at the history of the 14th Amendment. It doesn't give us the result we want, so we're just going to ignore it. So we're going to go ahead. But at least Brown, right? At least Brown dealt with the Equal Protection Clause, right? Something that was actually in the Constitution. They can make a textual argument that denying African American students the right to access to school is denying them the equal protection of the law. You can make that argument with a straight face. But first in Lawrence, and now here, the court basically says, history plays no role in our determination. That people in the past were blind to what we see today, and we will embrace this new act of liberty and use it to invalidate the various marriage laws. So, this sentence I've highlighted in yellow: when new insights reveal discord between the Constitution's essential protections and a received legal stricture, claims to liberty must be addressed. That very well may be true, Daniel, but who is responsible for addressing these various new claims of liberty? Who is that job fall to?
Apparently it's the court.
You said apparently. Why apparently? Well, if it's not the courts, who's going to do it? How? So, the other aspect of this opinion is in the backdrop leading up to Obergefell, a number of states that actually legalized same-sex marriage. It's the 11 or 13, I'm drawing a blank on the number. 5 state Supreme Courts legalized it, which is different than when the people vote for it. But in almost every state, not every state, but in many states, the voters approved of it. The flip side is, in many other states, they rejected it, Texas and others. They put it on the ballot, and they actually amended their state constitutions to prohibit it. So the crux, though, of the Kennedy approach is this. When the court recognizes that there are these new liberty interests that need to be addressed, the court will address it, even at the expense of telling people that they were wrong. Right? So when people in Texas and elsewhere voted for these amendments, the court's saying that, don't worry, you're not a bigot, but you didn't see what we see. You didn't recognize the various claims that we recognize, and we'll take care of it from here. So with me so far. Questions so far? So I actually met Jim Obergefell a couple of years ago. He came to Houston, when was it, 2015 or 2016? I can't remember. Yeah, in 2015. He came to Houston for some sort of event. He was by Discovery Green a few blocks away. And beforehand, I just walked over to him and I asked, hey, how you doing? I chatted for a few minutes. I always have a constitution in my pocket. I said, hey, would you sign my constitution? So I have a collection of signed constitutions. If you ever come to our office, I'll show you them. I have a bunch of justices signed them, a pretty big collection. And a little background. I had asked Justice Scalia to sign my Constitution several times. He told me no twice. It's a funny story. So I asked him once to sign my Constitution. He said no. I asked him again. He said no. I got smart. So Justice Thomas came to visit my law school, and I asked him to sign my Constitution. He was like, yeah, sure, whatever. He signed it. So then I went to Scalia a third time. Justice, will you sign my Constitution? And he said no. I said, Justice Thomas signed it. He was like, give me. And he frantically signed it. But I considered when I gave it to him to have him sign the Second Amendment, because he'd just written the Heller decision. That'd be kind of cool. So in any event, when I gave Bergefell the Constitution to sign, I didn't open up to the front page. I opened up to the page of the 14th Amendment. And what he wrote is, I'll zoom into it. What he wrote is actually, I don't think it was deliberate, but it was an amazing thing that he wrote. So you have the 14th Amendment here, you have section 1, 2, 3, 4, 5, and then below that, he wrote basically section 6 of the 14th Amendment. He wrote, Jim Obergefell, love one, L-O-V-E-1-O-N. L-O-V-E-W-O-N, love one. See it right there, you can pass around later. I'll pass around, what the hell. Just make sure I get this back from the class. If it disappears, I'll know where it is. Cameras, right? And, you know, I was just looking at this, like, wow. What the court basically does here is it says, our entire framework for constitutional law we're just going to put aside. There's no recognition that gays or lesbian or suspect classification. There's some discussion of whether there's a fundamental right, but the court doesn't explain why this right is fundamental. In other words, it doesn't explain that this is a right that's rooted in history tradition. It basically ignores its own framework for discussing what a fundamental right is. It makes this new rule that where these new liberty interests, the court will address it. And it puts forward a 4-factor test, which I'm sure we can walk through in good time. But the nature of this decision is basically saying we're going to put aside all this other stuff we've been doing for years. We're not going to overturn anything. We're just going to put this aside, and we're going to rule in this fashion. So to answer your question of what does Obergefell mean for constitutional law in your midterm and your final, I don't know. It's unclear what role concepts like dignity play in the Constitution. It's unclear what role things like autonomy play in the Constitution. So I want to walk through this analysis, telling you with complete sincerity, I don't know what any of this means, and I don't know what it means for the future of constitutional law. But I want you to at least understand the opinion we have here. Okay? So questions so far? Questions so far? Andre, is that a hand? Yes, sir.
Yeah, I just got a quick question.
Please.
So is he trying to say that with something so important, you can basically just break the rules of the Constitution?
Well, is scrutiny a rule of the Constitution?
Well, I guess break the rules of precedent.
So, all right, let me answer Andre's question. I'll do this later, but I'll do it now. So there's a case called Washington versus Glucksberg. Okay, this case involved whether there was a constitutional right to assisted suicide, not bestiality, suicide, right? I'm not letting that go, sorry. Whether there was a constitutional right to assisted suicide. And the court said, no, there's no right to suicide. Why? Because we've been criminalizing suicide for like ever. It's been a crime. You can't, actually, assisted suicide is a crime. If you kill yourself, you can't be prosecuted. But assisted suicide is a crime. How can it be that suddenly this right to assisted suicide is protected by the Constitution? So what the court said is we only protect those rights that are deeply rooted in tradition and history. In other words, if the right's not written down, it's a liberty aspect of the 14th Amendment, we look to history. And what Kennedy says here is, no, we're not going to do that. He basically overturns Glucksberg. Roberts makes his point in his dissenting opinion. And there's nothing wrong with overturning Glucksberg. I mean, Kennedy joined it begrudgingly, I suppose. But it changes the way the court recognizes fundamental rights in a very different way, such that we can just recognize new rights that exist today. How do we know if the right exists? Well, he says, look, people write about it. There are articles, and people write law review articles. They talk about it, they debate it, but the debate's over. And this sort of flexible framework has no bounds. It doesn't pretend to. And this is not criticizing to agree or disagree with the decision. There's actually a book being published now by a bunch of fairly liberal law professors called What Obergefell Should Have Said. And the entire book is writing opinions that should have been written by the court, because they say the opinion doesn't really hold its weight. If you're ever interested, Judge Posner's opinion in the Seventh Circuit below, which struck down the marriage laws, I think, in Wisconsin, is worth a read. It's a fairly, Posner's a fairly straightforward opinion. He said, look, we're going to apply strict scrutiny under equal protection, strike it down, easy. But that's not Kennedy. He doesn't go for that. Does that answer your question, Andre? A little bit? In other words, you could have written an opinion that fit within precedent to do this, and my reaction to that would be completely different.
It kind of reminds me of like in Lawrence v. Texas, that O'Connor's great opinion, how she gets there using precedent with equal protection.
She tries to fit it in, right? Yeah, exactly.
As opposed to just making this up.
Yeah, and I have a similar reaction to this case as just the Obamacare case, right? If the court had just upheld the mandate as an exercise of Congress's commerce powers, like, all right, whatever. But it's the making stuff up that makes me agitated, so to say. But yeah, go read Posner's opinion. I should probably assign Posner's opinion over this one. It's better to read. But if you read Posner's opinion in the Seventh Circuit, it's straight up, very clear. There's not much of any ambiguity there. Okay. But I want to walk through the four, I'll call it the four factors. I don't know if that's the right word. But the four factors of the majority decision. Okay? So he says, first off, the rightful choice regarding marriage is inherent in the concept of individual autonomy. Who's next? I'm sure I'll skip you. Jonathan. What does that mean, John? This is the first of his four factors.
It's the most intimate decision somebody can make.
Okay.
So it's crucial to individual autonomy.
Yeah, defining it by defining it. Thank you. I don't know what it means. I'm picking on you. I'm sorry. I've read this many times. So, the right to personal choice regarding marriage is inherent in the concept of individual autonomy. That is, if you don't control. I'm sorry.
I was just saying wrong one.
I'm sorry. I didn't know what you said.
I was saying wrong one. I opened the wrong. Sorry.
You can flip through. There was a card there. Now marking the page.
Yeah,
So what you
it's
did.
in there. Sorry.
So, what the court's basically saying is that there's a certain dignity that's derived from choosing who you're married with. And merely living with them and loving with them, engaging in relations with them is not enough. That the idea of marriage, the idea of marriage, thank you. The idea of marriage is something very different in that bond. The court says that the right to marry is fundamental, so you're going to actually try to fit it into the framework by calling it a fundamental right. But if you look at how the court had defined marriage before, right? For example, Elizabeth, they say that Griswold said that marriage is as noble a purpose as any involved in our prior decisions, right? Why did the Griswold opinion think marriage was so important? What about marriage that was so significant? Yeah. Why is procreation so important?
Because it's how our society is.
Yeah. Yeah, if we stop having sex, we stop reproducing. Our society dies very quickly. Right? If there was some sort of zombie plague that made us all sterile, we'd be done very quickly. I mean, as you recreate artificially, robots, but in theory, right? Our society cannot exist. So the reason why courts engage in this recognition of marriage is because of procreation. All right, so now, Zach, let me ask you a question here. According to the government in this case, what is the reason why the government has laws to allow only men and women to marry, but not opposites, not same-sex couples? What's the government's interest here? It's a good time to explain it. What's the government's interest here? It's not that hard of a question. Smells like burning.
Yeah. Like plastic or rubber. Yeah.
Okay. Go on, Zach.
I'm with you as a little. I mean, the government's interest in.
What's the government's interest here, right? If we're saying that marriage is closely tied to procreation,
It's protecting the children and the rights related to procreation and childbearing.
what do you mean protecting the children? Give me a little bit more, please.
I mean, they said it safeguards them because having a family of married parents is better for them. There's like a stigma.
Is it always be better?
What?
Will it always be better for a child to have a father and mother?
Well, they just, the court says.
No, I'm asking you in general. Is it always going to be the case that having a father and mother is better than having a single parent?
Depends on who you ask, but yeah, generally.
Generally, it's not always.
There's situations. I mean, yeah, there's people with single mother that have been fine.
Right. So we be candid, right? In some cases, you have two abusive parents, a mom and dad, who abuse the crap out of the kid, and that's bad. And in some cases, you have a single parent who's a fantastic parent, and in some cases, you have two men or two women raising the kid, and they come out just fine. They come out healthy, right? But the government's argument is, as a general matter, historically, the reason why marriage existed was to encourage people to have responsible child, right? To encourage people to raise children responsibly. Think about it like this. You're back in the olden days, right? You're in the state of nature somewhere, right? Long before society existed. A child will have a much better chance of living if there are two parents instead of one. Okay? In most aspects of society, raising a child is a hard job. I have some of you bring your kids with me to office hours, right? It's great, but it's a hard role, right? And having people to help out is generally going to be conducive to the child's development. So marriage exists, or at least the government argues, to ensure that children have the best shot at success. And by rewarding people who get married with certain benefits, tax otherwise, it encourages this. It encourages responsible child rearing. Now, is this always going to be the case? Of course not. Right? There are plenty of husbands and wives who abuse their kids and treat them horribly. There are plenty of single parents who do a great job raising kids. This is not disputed. But as a general matter, or even as a likely matter, is this interest legitimate? Is this interest there? Now, if you read O'Connor and Lawrence, Andre mentioned her a minute ago, she says, yeah, it's perfectly legitimate for the state to have marriage to encourage responsible procreation. It's not a guarantee, but it's a possibility. What the court says here is that's not enough. What the court says here is it's not enough to say that opposite sex couples might be better for children. You have to be more precise. That interest is not valid. And once you're saying we're not going to allow that interest to prevail, there's no reason why gays and lesbians can't be married, right? Once you separate marriage from procreation, which is what the court does here at some length, the argument's very easy, right? If the purpose of marriage is not about children, but about love and intimacy and dignity, well then of course, why can't gays and lesbians can't get married? They can love just the same as anyone else, which is why Mr. Bergerfeld came to us, my constitution wrote, love won. That's what won here, right? Love. That the court made marriage not about procreation, but about love, which is fine. That's a perfectly valid sentiment. But to do that, they have to basically abandon what the role of marriage had traditionally been, which is that procreation. Right? Once you decouple marriage from procreation, this case is easy. But that's a really big deal to do that. Okay? The next part of the opinion, the third part of the court's analysis, talks about children and families. Right? And this part's exactly right. If you're with unmarried parents, there's a stigma. It says your parents are lesser. Right? There's humiliation and harm. That's absolutely true, and I don't think anyone denies that. But you only get there once you decouple marriage from procreation, right? If you don't get over that first hump, you don't get to point 3 at all. So, despite all the criticism of Kenny's opinion, there actually is a fairly logical flow to it. Actually, he had smart law clerk that term, right? People work on this, but they actually finessed it to actually get to some reasoning. Okay? And the final one, the fourth purpose, is that marriage is a keystone for our social order. Okay? At that point, marriage is nothing but procreation, and it's about letting people achieve their highest transcendent purpose. that means, but the highest value. So that's the court's analysis. There's not much more for me to say about it. I can ask some questions, but that's about it. Once you get past saying that marriage is not just about procreation, tradition really doesn't matter anymore, it's a real easy opinion. Real easy to write. So questions in the majority. Yes, sir, Kevin.
I know we talked about this last class with polygamy, but I can't help but see a connect tie to polygamy if this would ever get accepted by the court.
Yeah, so Chief Justice Roberts makes this point. He says that randomly the majority inserts the word two throughout the opinion. Say two people, why two? If people can seek a new transcendent dimension of love by having a third wife or a fourth wife, or whatever it happens to be, why can't they? The majority has no answer. I think I said this last week. What makes me the most angry at Kennedy, he never acknowledges a dissent, ever. He just never mentions it. So Kevin's question, why not polygamy? Roberts writes about it, there's no response. But as it turned out, there was a case from the sister wives to the Supreme Court they did not review. It's a lot easier to just do that. They don't have to take all the cases that come before them. Okay. So any other questions on the due process part of the majority analysis? Yes, Mark.
So I think like by trying to sound progressive in his holding, he kind of slid back a little bit by bringing up stigma around children and single parents.
Yeah, did you all notice that?
Like,
isn't that strange?
I
To
mean,
say that the children of unmarried parents are like bastards, basically?
Yeah. So many of us were raised by just our mom or just our dad these days. There's not a stigma associated to this. But kids are cruel by nature, and I can guarantee you...
Were you a cool kid?
I was. Admittedly, and that's something I have to live with. But,
oh, I'm sorry. I didn't mean to pick on you.
No, it's
Sorry.
okay. Good point. But you can't tell me that, you know, if a kid comes from a same-sex couple, that he's not getting teased. You know, so I'm not saying that he should or that's right, but I think that he's kind of having like a pink cloud moment here. That's
A what moment?
A pink cloud moment.
A pink cloud.
That's not realistic.
Well, let's go back to this one, right? Can a parent have a reasonable, sincerely held belief that the children of gay couples are worse off? Or, let me ask this question differently. This is actually a legitimate issue now. Could a parent giving a child up for adoption say, I don't want my child to go to a gay couple? Could an adoption agency say, we will not place children with gay couples? I'm sorry? A lot of them, especially the Catholic charities, will not. For example, I think it was Massachusetts, might be Illinois, I think it was Massachusetts, has a law that says that adoption agencies cannot discriminate against couples based on sexual orientation. So the Catholic charities said, okay, we'll stop performing adoptions. So now children just won't be placed at all under that auspice. So we haven't talked about free exercise and religious liberty. We just haven't talked about it in this class at all. But there's a passage at the end of the opinion, the very end, like the second to last page or so, where Justice Kennedy says that, you know, people are still free to advocate for their beliefs. He does not use the word exercise. He says advocate, which means teach and speak about, but you can't actually follow through. So some of you may know about the cake cases here, the Supreme Court, the mass cake shop case, where you have bakers and photographers and florists who don't want to perform services for gay weddings. This decision did nothing to address those claims, and maybe it should, nevertheless, you know, a big decision. I want to mention briefly equal protection. The equal protection component here feels like an absolute afterthought, right? He kind of shoves it in at the end and doesn't really give it a lot of attention. The court does not hold that we have a suspect classification that warrants strict scrutiny. They don't hold that. But they say that equal protection and due process are like interwoven, right? They're connected. Each concept leads to a stronger understanding of the other. So Kennedy doesn't really care much for clauses. It's irrelevant to the grounds on which it's decided. Now, why does it matter? Well, if the court had held that classifications on the basis of sexual orientation are suspect, a lot of laws become unconstitutional. So perhaps they were trying to avoid that here. But they left that issue wide open. Okay. Any other questions on the majority opinion? I'll try to summarize it. The court says that when defining liberty interest in the 14th Amendment, you're not bound by history, and you can consider newly understood liberty interests that weren't understood at the time that the 14th Amendment was drafted, or even 14 years ago. And if the court determines that such liberty interest exists and a government law infringes upon those ways to deprive a person of his dignity, it's unconstitutional to the due process clause. What is the rule for identifying new liberty interests? I couldn't tell you. I wish I could, I don't know. No one knows. Teaching this class every year is a learning curve because the court's always changing things. So always have to keep up with what the latest opinions are. Okay. Any other questions in the majority opinion? It's been for the second half of the class, 100%. Oh, sorry, Elizabeth, I'm sorry, I didn't see your hand.
Have they not applied this framework to any other
Not
classes?
yet. They might soon. There was one case from Arkansas which applied it, but in a very different way. What was it? Arkansas, case of Pavan v. Smith. Arkansas had a rule about if you had a same-sex, when a child was born to unmarried parents, the husband was automatically listed as the father on the birth certificate. The baby dad, the biological father would automatically be listed as the father on the birth certificate without a paternity test. But in same-sex couples, they wouldn't have that sort of automatic presumption. So the court, in a very brief opinion, wasn't even argued, struck that down and said it was inconsistent with Obergefell, because Obergefell said you have to give marriage licenses and birth certificates to gay couples in the same terms as opposite-sex couples. So that wasn't necessarily controversial. So that extended Obergefell, but not much. The marriage case involving the bakers and the photographers and the florists, that may implicate that this year. So long after you finish my final exam, maybe I'll have an answer for your question, but I can't answer it yet. So any questions in the majority? Yes, Zach?
So they pretty much redefine what liberty interest is by redefining marriage.
Well, if you ask Justice Kennedy, give an audience with the Pope, right? If you ask Justice Kennedy, he will say, I did not redefine marriage. Society did, and I simply recognized it, right? And I want to be very clear. Kennedy, I don't think believes he's making stuff up. I think he's just, like absorbing what's around him and saying, aha, I see this, like, the oracle. I see what the truth is, and he's defining it. So he's not just making it up. But generally, when you talk about how marriage changed, we don't have coverage anymore, right? These are all changes by the democratic process, not by this judicial instigation. So other questions in the majority opinion by Kennedy? You know why I had to read the entire case, right? This one you can't edit down very well. You can, but you miss way too much stuff. Yes, ma'am, Emily.
It's on the last page of Kennedy's opinion when he talks about the differences among the states in the state's marriage laws. I thought it was somewhat compelling to say that leaving that uncertain
That's true.
is itself a compelling reason to have a law stating that marriage between same-sex couples is legal. And I think that was a callback to Windsor.
Good.
He didn't cite it.
No, very good point.
I thought that was a compelling enough reason he could have expanded on.
So what's Emily's point? Her point is this, right? At the time Obergefell came to the court, roughly 30-something states, or I think almost 40 states, already had gay marriage. For the court to just punt on the issue would leave this strange situation where you can get married in one state and not in another state. And that the court was simply resolving it and clarifying that confusion. That argument would sit with me a lot better if he hadn't struck down the Defense of Marriage Act 3 years earlier. Because the purpose of DOMA was to prevent that confusion with having in some states, not in others. Right? In other words, after he struck down DOMA, he basically paved the way for all these challenges. And once Windsor was decided, states stopped enacting democratic means. They went to the courts. In fact, I'll give you an example. In New Jersey, It was actually the New Jersey legislature passed a bill to legalize gay marriage, and the governor vetoed it, Christie. He vetoed it. Okay? About a year later, a trial judge in New Jersey struck down the law. Right? The New Jersey legislature considered, should we pass this bill, right? It was only a trial court. Should we pass this bill and legalize gay marriage? And no. Let's just let the courts do it. We don't have to do it ourselves. So people are all too happy to let the courts do their dirty work and they'll take a tough vote. So that's exactly what happened. So by the time you got to a majority of the states allowing gay marriage by legislative process or judicial, you were beyond the point of no return. You couldn't go back. Let me give you another example. In Utah, right? Utah. A judge struck down the marriage law, I think it was on December 24th. It was either on Christmas or Christmas Eve. He did not stay his decision. The Utah Attorney General's office was basically on Christmas break by that point. They couldn't get an appeal up for almost a week, right? They just weren't ready for it. They didn't think it was coming. And during that time, hundreds of people got married, right? Eventually the Supreme Court intervened and said, okay, you guys, put this on hold. But by the time the Supreme Court intervened, hundreds of people got married. What would have happened if Obergefell reversed? Would you actually yank away those marriage licenses from those couples? Well, those couples already filed married tax returns and adopted children and done various things married couples could do. You have to take all that back. So once you had a single judge rule in this fashion, you were past the point of no return. You couldn't undo it. Which is why Windsor was the only case that actually mattered. Once you had Windsor, it didn't matter. Everything else was a fait accompli. Right? Once you eliminate moral disapproval as a basis to exclude gays and lesbians from marriage, the marriage laws are toast. So at that point, Emily, your point is, it was a done deal, right? He could have just said that. Yep, following Windsor, we're done. That's why Windsor. That's why Scalia was so angry in Windsor, because he knew what was on the wall. Like he knew what was coming. There was no mystery what was happening next. In fact, I think within 24 hours of Windsor, I might be wrong, lawsuits were filed across the country challenging the Utah law and all these other states. The procedural aspects of those cases were crazy. The judges were issuing rulings and putting them on hold. And you had these, one judge, my favorite, judge, I can't remember her name, in Virginia, she rushed to get her opinion out on Valentine's Day, right? Love. And she had this entire thing where she had this long quote from the Constitution. And she said, this quote from the Declaration of Independence. And she misquoted the Constitution from the Declaration. But she rushed on Valentine's Day so people get married on Valentine's Day. It's very sweet. Sorry, I read about this one length. The procedural aspect of this case driving batty. The substantive I can live with. All right, other questions from the majority. Yeah, Carlos.
Well, I was just going to ask you a question about the case, or what you had mentioned was going on in New Jersey. And that kind of reminds me of the case that we talked about, the nuclear waste and commandeering.
Yeah, good memory. Yeah.
And that, is that analogous? Is that essentially what they did? Was they didn't want to cash in the political chips, so they allowed...
Yeah, it's actually even worse than that. So I'm actually presenting a paper on this at NYU tomorrow, so I'll give you a preview. The thing in New Jersey was that the bill had certain religious liberty protections, right? The bill would have actually created exemptions that a clergy member can't be required to perform a same-sex wedding, right? The bill had certain protections. Once the court ruled, there was no need to negotiate. They didn't have to assuage concerns of religious liberties. They just said, all right, screw it, we don't need the bill anymore. They withdrew the bill on the suggestion of a gay rights group, and that's why the bill wasn't passed. They said, let's just go through the court decision, which has no carve-outs of free exercise. That's the actual reason. It's a little bit worse. So, that's where it is. Yeah, David.
What's the common practice or efficacy of a justice citing their own opinions? So
why do you say that?
Because Kennedy cites his opinions he wrote quite often throughout this.
Yeah. Look. So I'll answer this question two ways. He wrote the opinions in Romer, Windsor, Lawrence, and then Obergefell here. That's the entire basis of our modern gay rights jurisprudence. So it would be impossible to write a gay rights decision without citing those cases, right? You couldn't do it. But on the flip side, he's basically citing himself, right? So that's what it is. Exactly.
Well, Scalia and Lawrence, in his dissent, I'm pretty sure he cited one of his own dissents.
Yeah, Scalia does it all the time. Yeah, so I mean, there's nothing wrong with citing yourself. It's better when you do it when there are 5 votes. Scalia decides his own, cites his own dissents all the time. Is there any question of the majority? Very uncertain times. I mean, it's a question. I don't know where dignity falls in our constitutional law. If Justice Kennedy retires in a couple of years, does any of this matter anymore? Will his replacement care at all about these things? I'll tell you this much: lower court judges aren't writing opinions about dignity. They don't even know what to do with this. So it's something of a very much open issue. Anything else from the majority? Yes, sir.
Do you think you mentioned that it's because the majority of states had already legalized gay marriage that had something to do with it? I'm not trying to change the subject.
No, you're right. Well, about 11 or 13 states passed it by the democratic process. A bunch of others passed it by state court decisions, and the rest by federal court decisions. So I think this is Emily's point. You get to a point of no return where you have enough critical mass, right? You have a critical mass of states, you can't go back. So I think that was definitely on their mind. Because let me answer this. There was a second part of the opinion which I usually don't talk about. But one is, does the state have to issue licenses to gay couples? 2, do they have to recognize out-of-state licenses? So what the court had just held, that you don't have to issue marriage licenses, just recognize out-of-state licenses, right? That could have been a middle ground, in theory at least, right? You don't have to license them yourself, but if someone moves to your state elsewhere, you have to recognize it. But the court didn't touch that because the first question was, you have to license it yourself. So perhaps they could have limited it, saying, well, Texas, you don't have to give gay marriage licenses, but you have to recognize them from out of state. That would have undercut the majority opinion a lot, because saying, if this is such a fundamental right, how can states deny it? But that was a potential part of the case, which didn't get very far. Anything else in the majority opinion? All right. There are 4 dissents here. How many cases have you read this year with 4 dissents? Any? I don't think any. Anyone check me on that one? I can't think of any. This was a big deal. And I'll tell you one thing. Chief Justice Roberts doesn't write many dissents. He just doesn't. He dissents a lot. He'll join Roberts or Alito or Scalia or Alito or whatever, but he very rarely writes his own dissents. But he did here, and because he's the Chief Justice, his dissent is listed first. Where the heck am I? Oh man, you had a long break. You're next. Describe for me Chief Justice Roberts' dissent, please.
He basically says that they don't have the basis to redefine the definition of marriage.
Good. Right. Roberts basically says this might be a good argument for social policy and fairness, but the court's not a legislature. And to the extent that the court can protect unenumerated rights, those rights have to be rooted in tradition and history. And the majority doesn't even make an excuse to say that this is rooted in history and tradition. They take this extraordinary step. And Roberts' one line I think is actually a good line. I wish Scalia would have used it. Many people will rejoice at this decision, and I begrudge none for this celebration. In other words, you can read this and still be happy for the couples getting married. And if you recall the day this was decided, people were running to the courthouse and getting married. It's a beautiful thing. But for those who believe in a government of law, not of men, the majority's hope is disheartening. And his next point is worth studying. He says, supporters of same-sex marriage have achieved considerable success persuading their fellow citizens. But this ends today, all right? Because once this decision comes out, there's no more debate. The debate's closed. Now, the next sentence I want you to focus on. 5 lawyers. 5 lawyers? Have you ever seen an opinion of the Supreme Court where they refer to their colleagues as 5 lawyers? Never. When I read this, I was like, oh shit, right? I was like, oh, Roberts, who is Mr. Statesman, right? There was an expletive, if I was something even a little more vulgar, right? Roberts, the statesman, called his colleagues 5 lawyers, not 5 judges, not the majority, not my colleagues, 5 lawyers. All of you, better pass the bar, will be lawyers, right? He's saying that if you guys pass the bar, that you have no more license to decide people's rights than the 5 people on the Supreme Court. So 5 lawyers have closed the debate and enacted their own vision of marriage as a matter of constitutional law. Stealing this issue from the people will for many cast a cloud over same-sex marriage, making a dramatic social change that much more difficult to accept. So let's go back to our quote. So I pulled it up there for a reason. After reading the majority opinion, where the court says that denying people these rights, denying them dignity, is your belief still reasonable? Can you hold a sincere belief in denying someone their dignity? My God, right? How can you be a reasonable person by denying a person their essence? So by reading this decision, Roberts is saying, you are making this statement be false, right? It's a false statement. You can't read the majority opinion, take it seriously, and still hold this belief. Then Roberts says, this is Federal 78 in reverse, right? The courts are supposed to be the least dangerous branch. It's supposed to exercise neither force nor will, but merely judgment. But this is a decision that's merely an act of will. And then it comes to Lochner, right? Case, what's the chief talking about Lochner? I mean, this is our bugaboo, keeps coming back to us over and over again.
Well, he's talking about when the judges decide, what they think is right instead of what, what the actual Constitution requires. And that's what he keeps hitting that point. It's all about their opinion and not necessarily the correct interpretation.
Yeah, I mean, the long-standing interpretation of Lochner is that judges basically made it up. They were social tolerant, they were laissez-faire economists. They believed in limited government, and they made up this right in the Constitution of liberty of contract, and they manufactured this, and they used it to thwart the democratic process. And he's saying this is no different, right? But at least with a right of contract, they could say this is something that was deeply rooted. It was understood in the 14th Amendment to have free contract rights. But here the court separates any notion of rights from history. And he keeps calling them 5 lawyers over and over again. It's a stunning thing. I'll pause. Did anyone see Scalia's footnote in that paper bag? Anyone notice that one? Let me get the exact quote. It's on, where is it?
I would type on him. 49.
Thank you. Yeah, page 49. You want to read it? I don't have it in front of me. Quick.
The Constitution promises liberty to all within its reach, a liberty that includes certain specific rights that allow persons within a lawful realm to define and express their identity. I would hide my head in a bag.
So, thank you. So Scalia is basically saying that if ever, as the price to be paid for 5th vote, I joined an opinion of the court that began with this sort of language, I would have put my head in a bag. They're really attacking their colleagues. I just want you to focus on this. This was a very bitter dispute. I mean, I think this was even worse than Obamacare. There was a story I read recently where Ginsburg said she had dinner with Scalia. Though someone had dinner with Scalia and Ginsburg the night after this was decided. He said it was very tense and very angry. I think there's a lot of hostility. Baker v. Nelson, right? Carlo, what's it do with Baker v. Nelson? That one I forgot to mention earlier. I'm sorry. The court jumps over it. Baker v. Nelson, decision from Minnesota Supreme Court, affirmed by the Supreme Court. What was that about? You don't have it?
I'm at a loss right now.
You don't have Baker v. Nelson?
Said it was a one-line summary decision that just held the exclusion of same-sex couples from marriage do not become a
Yeah. So I used to always quiz my students before a burger club. I said, has the Supreme Court ever considered the issue of gay marriage? I go, of course not, Josh, of course not. They actually did. So the decision was at 77, 78, I'd be also 72. Thank you, 72. There was a decision from 1972 where the Minnesota Supreme Court held that there's no right to gay marriage under the Minnesota or the federal Constitution. The Supreme Court issued a one-line opinion saying that we are agreeing with the Minnesota court. because there's no federal issue, there's no question of law. Those decisions are binding. So all the lower courts in Utah and elsewhere who ruled there was gay marriage are basically ignoring Baker v. Nelson. That's why the precedent factor just drives me bonkers, right? But the court says, oh, that was just wrong, we overruled that one right there. But that was a decision of the court. Oh, and then he gets to Dred Scott. Yeah. Yeah, so this is the long-standing critique of substantive due process, that because Roger Taney made it, all of the applications of substantive due process are like Dred Scott, which is sort of a weak argument, but the chief goes there. Back to Lochner. All right. Any other questions on the chief's dissent? Anything else on the chief's dissent? He's very angry. Yes, Rosario.
I have a question. I have more like a comment about it. About his quote, those who believe in the government of God, not a man, blah, blah, blah. So, my thing about that, even when you look at it that way, looking at his quote, I feel like in his view, no, you're bringing in more of your own morals. Because if you're focused on the law, then you would be focused on rights. So equal protection clause and due process clause would grant them that right. But I don't understand why he seems to think the opposite.
Why does the due process clause grant those rights?
That's my thoughts. I had it.
No, but your point is, if the rule of law is so important, then why don't gay and lesbians have the right to marry?
Yeah.
Okay, but then you have to say
my quote from when you saw my laptop, like his law is free from passion. It's behind the cover. Like, why are we bringing in the morals then?
But then that raises the question: is the majority opinion consistent with the rule of law? Right? If the majority opinion recognizes the right to gay marriage, is that position itself consistent with the rule of law? I don't have an answer, but if indeed the majority opinion is correct that Roberts is wrong, right? If indeed Kennedy's right, that this is what the Constitution means, then he's ignoring the rule of law. If Kennedy's wrong, if Roberts is right, that the rule of law requires looking for rights in history, then Kennedy's wrong, right? They can't both be right.
Right.
So either one's right, either the majority is consistent with the rule of law, or the dissent is consistent with the rule of law. They can't both be right. I'm sorry?
I agree with you.
Okay. Right. Either of them has to be right. They can't both be right. They're at very different ends. The majority saying the Constitution commands this right, and the dissent saying it's antagonistic to the rule of law for the court to develop these rights. Make sense? Okay, good. Any other questions in the majority? One more note on religious freedom. The chief mentions this. During the argument, I think it was Alito asked a question about what if you have a religious college that declines to let the same-sex couples to live in married housing in dormitories? Now, could that college lose their tax-exempt status? Okay. The flip side issue is, like, what if you had a college called Bob Jones in South Carolina, right, that didn't allow interracial couples, it's been a long day, interracial couples to live in married dorm housing? Could they lose their tax-exempt status? Yeah, they could. They would. They did. So what Alito asked the Solicitor General is, could a religious college loses tax-exempt status for excluding gay couples from their married housing? And the Solicitor General said, it's going to be an issue. Not yes, not no, it's going to be an issue, which is probably the only answer he could give. So going back to comparing this quote to, interracial marriage and loving, in 20 years, will people who oppose gay marriage could look the same way as the white supremacists who supported the laws of Virginia? I don't know. I can't tell you. I don't know. Yes?
I have a question on the majority.
Yeah.
Say, for example, like 30 states legalized marijuana.
Yeah.
And someone wants to come to Texas and they can't use their card, and they're saying like it's of their liberty. I just feel like it creates a slippery slope.
Well, Justice Kennedy has a very strange approach about counting states, right? So there was a case a couple of years ago called Kennedy v. Louisiana, which involved Louisiana wanted to execute, I think it was a child rapist, right? He wasn't a murderer, he was a child rapist. And Kennedy wrote this opinion and said that all states in the country, all 50 states except for Louisiana, maybe one or two others, have gotten rid of the death penalty for child rape, meaning you only get the death penalty for murder. And he wrote this opinion saying, look, there's like virtually no states that allow this. And then shortly after the opinion was issued, someone wrote this blog post and said, wait a minute, under military law, the UCMJ, the Uniform Code of Military Justice, you can get the death penalty for child rape. So the court had to actually amend its opinion and said, well, there's a consensus, but not that big of a consensus, right? So I would probably start counting states. It's a very weird thing. So you actually make a mistake, right? But that's not known in our jurisprudence. If there are 30 states that have already legalized X, just wait for the rest of them to do it. Patience or whatever. Any other questions on the Roberts dissent? All right. Kevin, let's go at Scalia's dissent.
So Scalia is basically saying that what the majority is doing is overstepping their bounds as a judicial system and going more towards the legislative system. Whereas what Scalia believes, it should be left to the people to decide whether they want to adopt this rule or law and go from there with each state.
Yeah, very good. So I want to focus for a minute on Scalia's opening. And I think he's come a long way in gay rights. I actually do. I think his opinion in Romer, we were talking about like AIDS and health risks, to here, I think he actually made a lot of progress. So he's saying the substance of today's decision, today's decree, he calls it a decree, like, you know, an emperor issues a decree. The substance of today's decree is not of immense and personal importance to me. The law can recognize as marriage whatever sexual attachments and living arrangements it wishes. It is of overwhelming importance, however, who it is that rules me. Right? Not just that they're lawyers, but that they're my rulers. Today's decree says that my ruler, and the ruler of 320 million Americans, coast to coast, is the majority of the 9 lawyers on this court. 9 lawyers, the majority of my rulers. In other words, this is a violation of the rule of law. But then he has another point, which people don't think much about. David, what was, according to Scalia, won in 1776? What major victory was obtained by the revolutionaries? What did we get from England? The most important thing we got from England by declaring independence?
People's ability to amend the Constitution.
Well, we didn't have a constitution yet in 1776, but you're on the right track. What did we get in that year that was so important?
Bill of Rights.
Well, that didn't come till a decade later. David, what did America get? Or let me ask the question differently. Before we declared independence, what could we not do? What could the colonists not do?
I guess like appeal to the king. I guess they're like make their own laws.
Govern themselves.
That's
right. There you got it. Good. Keep going.
The practice of constitutional revision, when unelected committee of 9, always accompanied by extravagant praise of liberty, robs the people of the most important liberty they asserted in the Declaration of Independence. And the Revolution of 1776.
Which is?
The freedom to govern.
The freedom to govern themselves. So I want to focus on this point because most students never think about this, right? Generally, when you think of liberty and freedom, you think of the liberty to abortion, sodomy, marijuana, right? Whatever example you want to use. You think of liberty as a government leaving you alone. But there's another aspect of freedom that people don't put much attachment to, is to govern themselves, right? That we're not under someone else's control. That we want to vote for something, vote one way, vote for the other way. When the court issues a decision, as they did in Obergefell, it removes from the political process the ability to resolve this question one way or the other. The 5 lawyers made their decision, that's it, we're stuck with it. And that these decisions rob the people of the democratic process and the ability to do this. And this itself is a violation of their own freedom. But Scalia says this ends the debate in an opinion lacking even a thin veneer of law. No matter what the people who ratified the 14th Amendment said, the 14th Amendment protects this right. He then goes on a very strange rant about the demographics of the court. Right? Have you ever seen something like this before? I haven't. He says, the 9 lawyers, Harvard and Yale, for 8 of them, almost all from East and West Coast states. Only one hails from the vast in-between. That's Robert, who's from Indiana. And no genuine Westerners. California does not count. That's what Justice Kennedy's from Sacramento. In fact, when Justice Gorsuch was confirmed, they made a big deal because he's from Colorado, he's a Westerner. Okay? They are unrepresentative character of the body voting at today's social orders. At the time, there were justices from 4 of the 5 boroughs of New York, right? Manhattan, Queens, Bronx, and Brooklyn. There was no Staten Island justice I would gladly serve, but not been called quite yet. But the court says that this is Scalia writes, it's a select patrician, highly unrepresentative panel of 9. So even if the court is trying to say that we are gathering the wisdom of the world, it comes from a fairly narrow slice of life, people with very insular and insulated views in different quarters. He describes this decision as a judicial putsch. Someone get the reference? The putsch?
It's a coup.
A coup. Do you know the reference? The beer hall putsch? You know this one? Hitler came to power with basically a revolution at a beer hall in Munich. It's called the beer hall putsch. So he's comparing this decision to the sort of usurpation of power by which the Nazis rose. You know why Scalia has no friends in the court. You know, it's you write these sorts of things and you burn bad blood, as they say. All right. Style's egotistic. Oh, ask the nearest hippie. Those are my favorite lines, right? He writes, one would think that freedom of intimacy is abridged rather than expanded by marriage. That is, when you get married, you have less freedom to sleep around. Ask the nearest hippie. The funny part is, David Nash, right? Crosby, Stills, and Nash came out and said, I disagree with Scalia, and I'm a hippie, so didn't even get that far. Okay. Any other questions in the Scalia dissent? Yes, sir.
He's calling them like the judges that kind of rule from the ivory tower kind of thing.
Oh, this is worse than ivory tower. He's saying that they're prideful, egotistic, hubristic rulers, right? Thank God law professors have no power. Like, we have none, right? We write stuff and no one listens to it. But when Kennedy writes stuff, people listen because they have to, otherwise they'll go to jail. Right? So this is not just ivory tower. This is on a different level. Lord help us. William F. Buckley was the founder of National Review. He once said, I would rather be ruled by the first 500 names in the Boston phone book than the faculty of Harvard University. I agree. Sincerely. All right, so any other questions on Scalia? All right, Evan, what's up with Justice Thomas?
Justice Thomas is kind of following in what the other judges are dissenting with. He's basically saying the majority is straying from the Constitution, and I guess he just really can't agree with it, especially when they're taking away more rights from the people.
How does Evan? How does Thomas define the word liberty? How do you define it? Does it include something like a marriage license?
I guess he describes it. He says it most likely refers to power of locomotion.
What's it? Come on, baby, do it. No, what's sorry. What's the power of locomotion? You ever thought about it?
I guess movement.
Yeah, movement, right? Like a locomotive, a train, right? Thomas takes a very narrow view of what liberty means. He sees liberty as freedom from physical restraint. So if I grab you, I've deprived you of your liberty, right? If I tell you that you can't engage in a certain act, I've deprived you of your liberty. Evan, does Thomas think that denying someone a marriage license or a birth certificate or whatever else is at issue in this case is denying them the liberties? No. Okay. So there's a concept in law, which I think we may have talked about, a positive versus negative liberty, right? Thomas takes a view of liberty that's negative. That is, if you're being restrained bodily, they're grabbing you, they're doing something to your restraint, you're being denied your liberty. But what if you want a right to X? A right to a marriage license, right? You want a piece of paper. In Thomas's grounds, that is not what liberty means. Even if you think about abortion, right? They're saying you can't get this procedure. Sodomy. We're going to restrain you from engaging in an intimate act. Birth control. We're going to stop you from putting this pill in your mouth, right? All those cases involve negative liberty. But this case is not merely about what people can do in their intimate conduct in their bedrooms. This case is saying we want the power to make you go to a government office and give you a license. And Thomas's point, which again is not rebutted by the majority, is that there's really no decision at all of any court saying that you have to give someone a government license. Now, the closest is Loving, right? Loving did describe interracial marriage. It was primarily an equal protection case. Due process analysis was more like an afterthought. But here, as a matter of due process, the Constitution protects a liberty interest in marriage. So Brandon, let me ask you the next question. What if a state just eliminated marriage altogether and said we won't give anyone marriage licenses? We're going to just get out of the business. We're not going to waste our time with this. Would such a statute violate a protocol?
If a state wanted to do away with marriage,
Gone altogether.
would it violate this case?
Yes, sir.
We guess.
Why?
Isn't it assuming that marriage is a fundamental right?
Exactly right. Obergefell says that marriage is a fundamental right, and that it's central to a person's autonomy and dignity. If a person can't get married, their humanity is being deprived. So even though states were under no obligation to create marriage in the first place, I suppose, every state had, the removal of this, if we just eliminate marriage, period, I think that would actually be unconstitutional under Obergefell. And Thomas says it's a very different understanding of liberty, because liberty is usually the right to leave you alone, not the right to give you something. Everyone see the difference, right? In Griswold, they're saying you can't put this pill in your mouth, right? In Rose, saying you are required to carry this child to term, right? In Lawrence, you can't engage in sodomy. Here, it's you can do whatever you want in your bedroom, but we also have to give you this piece of paper, this marriage license, and the various tax benefits and otherwise that come from it. Everyone get that distinction? Yes, Aaron?
So you're saying that ability to them saying to leave you alone is negative liberty?
Yeah, leave me alone. Don't throw me in jail for having sex with my boyfriend, right? That's Lawrence. Don't throw me in jail because I don't want to carry the child to term. Don't throw me in jail because I want to pop a birth control pill, right? Don't throw me in jail because I want to work more than 80 hours a week at a bakery. Negative. Now, there's a species of constitutional law that's called positive. It's saying, well, if you ever read a European constitution, you'll see this. If you read a European constitution, they'll say, you have the right to housing, right? The Constitution protects the right to housing. You have the right to education. You have the right to health care. So if the government cuts your health insurance benefits, you can actually bring a constitutional claim. Our Constitution is one of negative liberties. That's generally how it's understood. Obergefell shifts that, again, without giving it much thought, and saying you have the right to positive liberty, just for the right to a marriage license. Another reason why an equal protection decision will be much more narrow than a due process decision, because this is actually of significant, startling breadth. By the way, one note, when Thomas talks about interracial marriage and loving, He lives in Virginia and married a white woman. So he actually, I put a footnote about this in the 3rd edition. His own marriage would have been illegal under the Loving regime. So there's some personal stuff there as well. All right. Anything else on Thomas's dissent? Anything else on Thomas's dissent? Yes, Emily.
Didn't he say that the majority bringing in Loving was improper, like, analysis?
Yeah, you want to talk about that for a minute? What's his discussion of Loving there?
I was hoping you would talk about it.
It's one of the more confusing parts of his opinion, but I'll try.
Okay.
So this is actually one of the parts of his opinion I think is actually one of the weaker parts. In my notes, I wrote, Emily, if you believe me. What does it say right there?
This analysis is confusing.
See, even I say the same thing. Yeah, his analysis of Bergerfeld is a little bit confusing, Emily. So I'm not making it up. So let me walk you through it. He says the comparison to Loving is offensive and inaccurate. Why? The laws concerning miscegenation, that is the bans of interracial marriage, were spawned by slavery and white supremacy. Right? The same laws that created slavery in Maryland and Virginia also banned interracial marriage. In other words, a marriage had existed for thousands of years before slavery came around. So what was redefining marriage was Jim Crow, right? That slavery was actually redefining marriage. So in a way, Emily, Loving was bringing us back to the original understanding of marriage, what it always was people of two sexes. Does that clear up a little bit? It's not awesome. It's not perfect. That's why I showed you my tablet. It's right there. Another aspect is crime. Loving was a criminal prohibition that if you actually tried to get married, you went to jail. Remember the case? They went to D.C., they got married there, and they came back to Virginia, they were thrown in jail. That's very different from this, right? Loving didn't actually involve whether it has to license marriage, right? It was implicated, but it was primarily a criminal prohibition of people getting married elsewhere. But I agree that this is not one of Thomas's more lucid opinions, this part. What did I say about this last year? Did I say anything more useful?
No, that's why I asked.
Very good. Zach, is your hand up? Yeah, I deliberately avoid that one because I think it's confusing, but it doesn't make a lot of sense. It feels forced. Is there anything else in Thomas? Who's next? What's Alito talking about?
Alito's reiterating the point that the courts have intervened where the people should actually be deciding whether to do the states themselves, and basically says that the Constitution says nothing about the same-sex right, and if the court finds this liberty in the due process clause, just kind of makes it up, basically he also reiterates that it's 5 unelected justices that are imposed.
He says justices, right?
He does say
Notice
justices.
Alito doesn't say lawyers. A little more respect, I suppose. Yeah, go on.
But he says that the 5 unelected justices are imposing their personal vision on the American people.
Yeah, and let's just go back to this for a minute, right? The court doesn't say whether strict scrutiny applies. They just don't use that word. But we talk about compelling state interests, right? Let's just say strict scrutiny applies. How do we define if an interest is compelling, right? Does the state have a compelling interest in creating a framework that will generally lead to better children that are taken care of, right? If the answer is no, then this case is easy. But Alito's saying that this was an interest that people for thousands of years never questioned, and only started questioning it 15 years ago, maybe 20 years ago, I suppose. Right? So what do we do with that, right? How do we understand, right? How do we understand this question? And Alito would say is, wait, marriage is decaying, he says, right? You have divorce, as Mark mentioned, children living out of wedlock is no longer a thing. There's not much of a stigma of having unmarried parents. if marriage is decaying, why can't the state maintain these marriage laws as a last-ditch effort to keep the status quo and prevent it from decaying further? This sounds a lot like Romer, doesn't it? Right? You want these sorts of laws to prevent this rapid social evolution. But according to the majority, these sorts of concerns are irrational. And to believe that opposite-sex marriage has this strong interest no longer matters. Alito also writes that this opinion will vilify Americans who are unwilling to assent to this new orthodoxy. And he compares, I think this is Emily's point, opposition to same-sex marriage to opposing interracial marriage as well. This implication will be exploited by those who are determined to stamp out every vestige of dissent. He writes, I assume that those who cling to old beliefs will be able to whisper their thoughts in the recesses of their homes, but if they repeat those views in public, they will risk being labeled as bigots and treated as such by governments, employers, and schools. By imposing its own views on the entire country, the majority facilitates the marginalization of the many Americans who have traditional ideas. Recalling the hard treatment of gays and lesbians in the past, some may think that turnabout is fair play. But that sentiment prevails, the nation will experience bitter and lasting wounds. So I go back to this quote, which I began our lecture with today. After reading this entire decision, right? After reading this entire decision, is opposition to gay marriage still a reasonable, sincere belief, or not? And I'm not even going to ask that one again. I polled you on that once, I'll poll you on it again. But the dissent is, again, not answered by the majority. So questions on Alito? Yes.
The last line that Alito mentioned in his dissent, warning the American public that the majority's claim of power is something that we should be watching out, reminds me of something he said at the Red Mass dinner.
Oh, good, you were there, that's right, yeah.
That dark clouds may be coming, but we should continue to push forward. And I feel like he's just basically saying the same thing over again, but in 2017, warning us of the power that the court has.
Was anyone else at the Red Mass dinner from here? I think Brittany, you were there. Yeah, Carlo, naturally, you were coming. I saw a few of you there. It was very crowded that night, so I didn't have more time to hang out. Yeah, so this is a losing battle for Alito. I think he knows it, right? There was a case which he referenced during his Red Mass dinner involving a pharmacy in either Washington or Oregon, right? Washington, yeah, thank you, Brittany. And the facts of the case were like this. The state passed a law which said that all pharmacies must dispense all forms of birth control. Not just all pharmacies, but all pharmacists, right? A pharmacist could not turn away. So what happens if you had a pharmacist who was pro-life and would not dispense the morning after pill? The state said that was illegal under state law. And this was appealed to the Supreme Court. And it was appealed to the Supreme Court during the period where there were only 8 justices, right? There were only 8 justices. And generally, you need 4 votes to grant certiorari. The review was denied. The court denied review. And there was a dissent by Alito, Thomas, and Roberts. Right? No Scalia, no Gorsuch, no Kennedy. And they dissented basically saying, look, if Scalia was here, we'd be granting cert on this case, but he wasn't there, so they had to deny review. But the sort of hostility to religious liberty that Alito discerned in his Red Mass dinner was that if you don't accept the new orthodoxy, your end result is basically submission. We force you to submit. And this is, I'll actually pivot to the First Amendment now, good segue. The big case this term, it's called the Masterpiece Cake Shop case. And it involves free exercise, which I'm not going to talk about now because we don't have time for it, but it involves free speech. And the facts are like this. You have a bake shop in Colorado, a fairly small bake shop. They make masterpiece cakes, or beautiful cakes. a gay couple walked in and said, we want you to make a cake for our wedding. And they said, I'm sorry, we'll make you a cake for your birthday, cake for anything else. You can take a cake off of our shelves, it's already made, we won't make you a custom cake. They were brought up on charges of violating the state human rights ordinance, which prohibits discrimination on the basis of sexual orientation. And they defend their case in the First Amendment, which we'll be reading about for next class. And they say we're being required to engage in compelled speech. So let me take a step back. Did any of you have a situation in grade school where someone didn't want to stand up for the Pledge of Allegiance?
Yeah.
What happened? Bingo. So there's a famous case involving Jehovah's Witness students, right? Called West Virginia v. Barnett. And the court, Justice Jackson, our favorite, right? Justice Jackson said that if there's any fixed star in our constitutional constellation, it's that no one can be compelled to engage in speech. That's why if a student won't stand up for the Pledge of Allegiance, they're fine. If they take a knee during the anthem, that's also protected by the Constitution, at least in a public school. So in the Masterpiece Cake Shop case, they argue that they're being compelled to engage in a speech act by making the cake. I don't know what the court's going to do there. I think it's a very tough call. Whether you're a common carrier, whether you're providing service, I think I have no prediction on the case. But to tie it back into Kevin's point and Alito's dissent, if we start from the premise that rejecting gay marriage is basically denying a person their humanity, the baker should bake. Baker's going to bake, right? I'll shake it off. So, sorry, really? I'm sorry, last day of class, after the evaluations, I'm sorry. I actually, when that album came out, I used to make a lot more Taylor Swift puns, and actually that class got me a Taylor Swift CD that semester, which I still have. Yeah, explain to her later. But the question is this, right? If denying people their marriage license is denying them their dignity, then the cake case becomes easy. But if this is true, and then there are perhaps sincerely held beliefs why this belief is, warranted, the case becomes a little bit tougher. I don't know what the court's going to do in the cake case. In fact, I think the cake issue is not as strong as photographers. Because a cake you make in a bakery by yourself, you don't have to actually go to the wedding. Whereas with photography, you actually have to go to the wedding, photograph, all right, we'll move around, give him a hug, give him a kiss, right? I think that actually is a much tougher case than the baking. This is a hard case. I have no idea. I don't make any predictions. Andre, raise your hand up. You're rolling. So any questions about the burger fellow with the cake case? Yes, sir.
But isn't it like you're saying, like compelling them to do something like as a private business? Isn't there still like some levels of discrimination, I guess, that like private businesses are allowed to?
Well, so here's the issue, right? Not all states prohibit discrimination on the basis of sexual orientation. I think 20 or so states do. And a lot of states basically exempt small businesses from a lot of discrimination laws. So you may not know this, but if you work for a small business with under 15 employees, federal employment discrimination law just doesn't apply to you, right? It doesn't. It just doesn't apply. States have various thresholds. Some states have 10, 5, some step 1. But the businesses at issue aren't going to ever make the case. They're never going to make them. They'll just shut down and go to business. So the end result of all this litigation will be basically, as Alito said, you're excluding certain people from the body politic that just won't engage in business. Or they'll maybe stop making wedding cakes, they'll only make birthday cakes. Although, as I understand, wedding cakes are the most profitable things they can help with make most of their money that way. So questions on that one?
It's interesting that you brought up the take a knee during the national anthem because Alito's dissent reminded
Someone
me
asked me that a few weeks ago, that's why I brought it back.
I heard an interesting discussion the other day about a guy who said, like, how many of us who are opposed to what these players are doing can say with a straight face that while they were at a game, they didn't run out to use the bathroom or to grab a beer before tip-off.
Yep. Yeah.
But now, while
I've been in a urinal Reliance Stadium during the national anthem. I've been there. I can attest it happens.
Right. So, and then it really, even last season when it was a grassroots effort, if people really weren't that bothered by it. Some people were. But when the president got involved and made it a much bigger production than it ever was before, it became this dividing issue. And I feel like there's some parallels to this. It's like maybe there were a number of people in states that were opposed to gay marriage who had gay family members, had gay friends, had gay neighbors, you know, that allowed them to, or didn't allow them, but were very comfortable with them living life the way that they wanted to. But then when it took a national stage, when the central government became involved, then it was like you needed to choose a side. It's like, why does everyone always have to need to choose a side?
Oh, I see your point. So I think Mark's point is when you make this issue so national, it forces everyone to pick one side or the other, right?
Exactly.
Yeah, and I think both Roberts and Alito allude to that. They say, look, because of this, debate's over. So either I'm, who was it? Team A or Team B, right? Right. You gotta pick a side.
Exactly.
On the taking of the knee, though, private businesses like NFL are not bound by the First Amendment, so they can do whatever they want to their players. They might have some free speech rights, which are collective bargaining, but they don't have any free speech rights to do anything at a sports game. High school athletes, though, a different story. Okay. Any questions? I'll try to synthesize the Bergefell into a summary, but I don't think I'll succeed. We studied long and hard about due process, legal protection. Our traditional framework is under the Due Process Clause. We look to whether a right's fundamental, and at least before Bergefell, the test was whether these rights are rooted in tradition and history. Right? Judges, when they're making up rights, they should be a little bit guided by something. That's out the window. Equal protection, we say strict scrutiny is applied when a suspect classification is at issue. The court doesn't mention it here. Instead, laws that infringe on dignity, autonomy, self-worth, these various other adjectives, that is prohibited by the 14th Amendment, irrespective of any particular clause. How does this apply elsewhere? I wish I could tell you. The Masterpiece Cake Shop case would probably be argued, I think, in January, so after your final, so you don't care anymore at that point. But if you ever want to come talk about it next semester, you're always welcome to stop by. Anything else? No? All right, I will see you all, some of you on Sunday, some of you on Monday, and some of you on Tuesday. The office hours.
No, I was like,
Yes, I come on the weekend. There are people.